Good morning. As you'll see, a rather unusual configuration. Lord Justice Arnold is in the ether, and I hope he can hear us. Excellent. And please, would you make sure that we can hear you? Would you say something for us, please?
Yes, I can hear you loud and clear, thank you.
Thank you, and we can hear you, so that's very helpful. I'm sure you'll appreciate that there is someone with COVID in Lord Justice Arnold's house, and so we've taken this step this morning. Before we go any further, I hope that you have managed to agree a timetable and that you know, therefore, where you're going today and over the days of this appeal.
Not formally, but I've indicated to my friend that that I would be about a day, and I will be taking the 2018 matter, and Mr. Morgan will be following me. He will be taking the 2010 appeal, and his last estimate was in the order of an hour and a half, I think.
And so that will be completed by mid-morning or a little later than that tomorrow.
That's the plan, yes.
And you're content with that?
I'm content with that. I anticipate I'll be a little over a day, but of course things might be truncated somewhat, depending on what my learned friends say.
Lovely. And therefore, you're content that there'll be enough time for replies? Good, just so that we know before we begin. Thank you very much indeed, Mr. Hart.
As the court knows, I appear with Mr. Morgan and Mr. Ostrowski for the canal, and Mr. Karras, Mr. Booles and Mr. Creth appear on behalf of United Utilities. I've already mentioned the fact that there are these two appeals. In terms of the paperwork concerning the appeals, the court will have skeletons from both the main parties in both appeals, and also submissions from the interveners who were granted a right of intervention in the 2018 proceedings, limited to their written submissions. And then the final piece of paperwork is United Utilities' response to that. The first appeal, the one I am going to address, is in the 2018 proceedings brought by UU for negative declaratory relief in respect of foul water discharged in contravention of two provisos. The judge gave permission for an appeal against his judgment on hand down. The second appeal, so Mr. Morgan's appeal, it concerns 5 outfalls in the 2010 claim, which are or were the subject of express agreements between the canal and local authority predecessors of United Utilities. And Lord Justice Arnold gave permission for that appeal subsequently. At one level, the dispute in the 2018 matter is about money. The canal wishing to be paid for the use which UU is making of its canal. At another level, and this is illustrated quite graphically by the submissions of the interveners, there are wider interests in seeking to make our inland waters cleaner, and the significance of there being a private law remedy available in order to assist in the performance of that objective. In the 2008 matter, I will take you through the legislation. I will try and do it this way. I'll start with the modern stuff, and then dip back into the key bits of the old material, which is important in this case, particularly in terms of some of the authorities which we will have to look at. But before the court will doubtless already have seen the judgments in the Supreme Court in previous litigation between these parties, in which there is a full-blown account of all the toings and froings of the history as to how we got to where we got to, and you may find that very useful starting place in terms of the structure of the legislation. But before I do that, can I go to the nub of my argument? Foul discharge in contravention of the provisos is not authorised under the 1991 Water Industry Act. That much is common ground. Given that lack of statutory authority, and on a proper construction of the Act as a whole, we say that Canal retains its ordinary common law remedies in trespass and nuisance. I say on a proper construction of the Act as a whole because one has to give content to those provisos and to their purpose, and which is to, in effect, delimit the extent of the statutory scheme. We say that proposition is unaffected by the fact that such a foul water discharge may and usually be a breach of the undertaker's general duty effectually to deal with the contents of sewers. Section 94, general duty. But that's another problem that an undertaker has to face if his operations go beyond its statutory powers. So there are two problems for them. There's the Section 94 problem, if I can put it that way, and there's the fact that foul discharges go outside the scope of their authority. If United Utilities is correct, and there is statutory ouster of such claims, we say the provisos would have little, if nothing, to do. Yet those provisos were retained and strengthened in some respects in the 1991 consolidation. Pre-1991 case law gives those provisos content, we say, and there are indications in the post-1991 case law, BWB and Manchester Ship Canal case itself, that the courts continue to recognise that. Our main argument is independent of the debate about the precise scope of Marchish, which you will have seen is our ground 3 debate about just how far it goes. For the very simple reason that Marchish was not concerned with the provisos, and therefore was not concerned with the point which we have here, which is that what the UU is doing is making unauthorised discharges. And we say that that is a significant difference. And then quickly, in winding up the remaining grounds, we say in no sense can discharge from United Utilities sewage system with its various outfalls and overflows and outfalls can be described as involuntary. And you'll recall the judge's use of that word in the judgment. It does, in practice and in law, amount to a trespass. So that's the whistle stop. Now I'm afraid to the statutory framework.
Now we dive in. Now we dive in.
Indeed. We start with, as I said, I'm starting with the 1991 Consolidated Act, for which you will need Authorities Bundle 1.1.
Can I just ask you, before you do that, you made the point that what is being done is a trespass. Does it matter for your argument whether it's a trespass or a nuisance?
It may not matter, but it's been characterised, certainly in the cases, as a trespass.
Well, quite a lot of the old cases treated as cases of nuisance.
Yes.
Is it something that is going to be important? I mean, obviously, at common law, discharging even clean water onto someone else's land is a trespass. Whether it's dirty or not doesn't make any difference, but clean water may well not be a nuisance. Dirty water will usually be a nuisance.
Yeah. Yeah.
Why does it matter?
I'm not sure it does matter a great deal.
Maybe we'll come back to it.
I suppose one is anxious, but possibly to find the right legal label, though as your lordship points out, it may not matter that much. So yes, the current Act in Bundle 1.1, and it starts at tab 12. 126 for anybody who's on the electronic bundle. And the first section in the Act at page 126, section 1A, which sets up the Water Services Regulation Authority, Ofwat. And throughout the Act, the authority is called the capital A Authority. We did note in this Gov UK copy of the Act, which is we find rather more user-friendly than certain other versions. It does have one little glitch, which you will see if you turn over to page 127 and look at section 2 sub 1, where there is a reference in the second line to the director. Mm-hmm. Wherever one reads director, one should read authority, since the 2003 Water Act. You will see the general duties under section 2 and sub 2A, which include the carrying out of functions at sea, secure that companies are able, in particular by securing the reasonable returns on their capital, to finance the proper carrying out of these functions, and that is in a sense, the general section within which the various players act.
And are the consumer objective and the resilience objective of any importance to us? That's A and E.
I think not.
2A.
I think
not.
I mean, only in this sense, the consumer objective is not to overpay for water and sewage services, but it's subject to that, no.
And the resilience objective, presumably, is providing a suitably resilient system.
That's right, and that's defined over the page, 2DA, long term.
But presumably, the consumer objective is not that water bills shouldn't be too high, and that does feed through directly into the question whether water and sewerage undertakers have to be required to spend whatever it takes to eliminate.
Absolutely.
So that is part of the consideration as to whether this Act enables private law remedies to subsist alongside the public law remedies. Because the argument you're facing is, if you're right, effectively, the court is going to require us to spend more money on building more sewers, and that will have to be financed by consumers.
Agreed entirely. It's comes back to my main point, which is that what it does have to do is act within the scope of its authority.
Yes.
And 2DA does have some relevance because it's also to secure, at little a, long-term resilience of water undertakers' supply systems and sewage undertakers' sewage systems as regards environmental pressures, and I can see that
Yes.
Feeds into the storm drains, etc.
Yes. What I was planning to do, this is not too eccentric, is to go to section 94 next and then come back to its enforcement mechanisms. And section 94 you will find at page 161. And the key, it's under the heading General Functions of Sewage Undertakers, and then Principal Duties and Standards of Performance. It shall be the duty, I read from 1, the duty of every sewage undertaker to provide, improve and extend such a system of public sewers, whether inside his area or elsewhere, so to cleanse and maintain those sewers and any lateral drains, so as to ensure that the area is and continues to be effectually drained. And then B, to make provision for the emptying of those sewers, such further provision, whether inside its area or elsewhere, as is necessary from time to time for effectually dealing by means of sewage disposal works or otherwise with the contents of those sewers. And we can miss out too, which concerns trade effluent. 94.3 is obviously important. The duty of sewage undertaker under sub 1 shall be enforceable under section 18 above by the Secretary of State or the Director, i.e. Ofwat. And then 94.4 should be noted. The obligations imposed on a sewage undertaker by the following chapters of this part, and the remedies available in respect of contravention of those obligations, shall be in addition to any duty imposed or remedy available by virtue of any provision of this section or section 95 below, and shall not in any way be qualified by any such provision. So we've seen that this is enforceable under section 18, and we can find section 18 at page 138 of our bundle. Subject to subsection 2 and sections 19 below, where in the case of any company holding an appointment, the Secretary of State or Ofwat is satisfied that the company is contravening any condition of the company's appointment in relation to which he is the enforcement authority, or any statutory or other requirement which is enforceable under this section and in relation to which he is the enforcement authority, or the company is likely to contravene such condition or requirement. He shall, by an enforcement order, make such provision as is requisite for the purpose of securing compliance with that condition or requirement. And what as the court may have picked up in your pre-reading, this section also contains at sub 8, page 140, a provision which, putting it shortly, preserves other remedies. But reading it out, because it's not the most straightforward, where any act or omission constitutes a contravention of a condition of an appointment under Chapter 1 of this part, or of a condition of a licence under 1A, or of a statutory or other requirement enforceable under the section, or causes or contributes to contravention of any such condition or requirement, the only remedies for or for causing or contributing to that contravention, apart from those available by virtue of this section, shall be those for which express provision is made by or under any enactment, and those which are available in respect of the act or omission otherwise than by virtue of it constituting or causing or contributing to such contravention. So you can't sue a breach of Section 94 duty in terms, but if you've got another claim, that is that may subsist. Very simple. And this, as you will appreciate, is one of the pointers amongst a number of pointers in the Act, suggesting that common law claims may survive. It didn't avail Mr. Marchich in the case of Marchich, for reasons I'll come to, but he couldn't simply say, well, I've got a common law claim, ergo 18 sub 8 lets me through, for the reasons which have been set out in that case. So that's section 18. At section 19 over the page, there are some exceptions to the duty to enforce. I don't think one needs to go there, but simply to well, perhaps just under sub 1. A, the contraventions were, we apprehended contraventions were of a trivial nature. B, person is complying with an undertaking, and C, the duties imposed by Part 1 of this Act preclude the making or confirmation of the order. So there are some exceptions in 19. Then please to 143. There is a procedure for the enforcement orders. Notice has to be given, representations, etc., etc. And then please to section 21 at page 145. Again, you can challenge the validity of an order. And then to section 22, the effect of an enforcement order. The obligation to comply with an enforcement order shall be a duty owed to any person who may be affected by a contravention of the order, where a duty is owed by virtue of section 1, subsection 1 above to any person, any breach of that duty which causes that person to sustain loss or damage shall be actionable at the suit of that person. Then there are I think the important thing to take away from this section is that it does bring in the person affected by the grounds which led to the enforcement order, that person doesn't have any chance to sue before an enforcement order has been made and the enforcement order is not being complied with by the undertaker. So a constrained remedy dependent upon Ofwat acting, making an enforcement order and it not being complied with. Now, we'd had a look at section 94, which was, just very briefly again, 161. Which is chapter 1 of part 4 of the Act, and it contains some general provisions about functions, but that if one then goes to rather more precision, one needs to go to chapter 2, which starts at page 170 and relates to section 98 and the sections following. And it's chapter 2 that has at the end of it the first proviso section, section 117. And if we can perhaps go to that key section 117, which starts 229. It's headed interpretation, and the key parts of it are over the page 230 under sub 5. Nothing in sections 102 to 109 or sections 111 to 116 shall be construed as authorising a sewage undertaker to construct or use any public or other sewer or any drain or outfall, A, in contravention of any applicable provision of the Water Resources Act or the environmental permitting regulations, or B, the foul water proviso coming up, for the purpose of conveying foul water into any natural or artificial stream, watercourse, canal, pond or lake, without the water having been so treated so as not to affect prejudicially purity and quality of the water in the stream, watercourse, canal or lake. And so the shape of it is that certain of the powers which the undertakers are given in chapter 2, and I'll deal with the salient ones in a moment, but they are, whatever exercise those powers may be on, shall not lead to the conveyance of foul water. So what are these? What are the provisions, and what are the important ones? Section 102, which is the first listed, concerns sewers adoption. Another important one is section 106, which was included in that section, and that is the right to communicate. and one can see that at see that, just briefly turn to page 200. So, your owner and occupier shall be entitled to have his drains communicate with the public sewer. And this is one of the provisions which was of it is of importance when judging the undertaker's response, because he the undertaker has to deal with whatever goes into his sewer, subject obviously to conditions. Then going back, please, to page 230, and in words of sub 5, or in sections 111 to 116. 116 is highly important, and one could see that if one goes to 227. Subject to subsection 3, sewage undertaker may discontinue and prohibit the use of any public sewer which is vested with the undertaker. 2, a discontinuance or prohibition on this section may be for all purposes, for purposes of foul drainage or for purposes of surface water drainage. And then the particularly important part, before any person who is lawfully using a sewer for any purpose is deprived under this section by a sewerage undertaker of the use of the sewer for that purpose, the undertaker shall A, provide a sewer which is equally effective for his use for that purpose, and B, at the undertaker's own expense carry out any work necessary to make that person's drains or sewers communicate with the sewer provided pursuant to this subsection. And it was that section which, in Lord Sumption's view, gave rise to the implied right to discharge, which had never ever been set out in crystal clear form in any of the legislation. So nothing in joining section 116 with 117 sub 5, nothing in the implied right to discharge into sewers shall be construed as authorising an undertaker to use for the purposes of conveying foul water. So there's an implied right to discharge non-foul water, but no implied right, sorry, the opposite, prohibition on discharging foul water, simply because the undertaker is not so authorised. We should note briefly 117 sub 6. Sewerage undertaker should so carry out its functions under the various sections above as not to create a nuisance. And you might say, well, there you are, you can claim under, claim that there's a contravention of that. It comes with a rider, and the rider comes from the case law, and because previous provisions along these lines by nuisance has been I can put it this way, a negligent nuisance, because the principle of Allen and Gulf Oil yes, the statutory authority, but if you're negligent, the defendant is negligent in the performance, that you lose that authority. So, my only purpose in taking you to it is simply to indicate that it does, in terms, contemplate Section 117 being about civil remedies, being about civil common law remedies. Even though it doesn't help us in this case because of Mr. Carris's concession that foul water discharges cannot be made if there's been negligence or as a result of deliberate discharge. But we say it is of some interest. The new boy or girl in sub 5 is A, which did not occur in any of the previous iterations. And we say there's something important, some importance in that. It makes plain that the various powers, including the implied powers of discharge, cannot authorise a permit controversion which can be cross-prosecuted. It does not get mandatorily sent off to Ofwat, even though it could. It may often amount to a Section 94 breach, and therefore it could get out that way. I.e., you can have proceedings in the criminal court, even if the consequence of those proceedings in the criminal court may involve an undertaker having to replace equipment at very considerable cost. So it is, in effect, flagging up a separate remedy. It's not enough to say, just because it's going to cost quite a lot, only Ofwat deals with it.
Who brings prosecutions for permit contraventions?
Who brings them? The Environment Agency. I think there is strictly speaking, a right to private prosecution, but in practice, it's always done by the Environment Agency.
Thank you.
Could I invite you to turn to passage in our skeleton, which you'll need core bundle 1 at tab 2. And please go to page 28 of the bundle. And what we do at paragraphs 37 to 40 is set out a very short, an account of just how the permitting process works in practice. I was not proposing to read that to the court, but I hope it gives some detail of just how these things work in practice, and how the Environment Agency is involved in the devising of the permits and imposing such elements as are required by by other legislation. And 39, permitting granting process takes place in the context and is preceded by the 5-year price review process. So I simply asked the court to read in due course those paragraphs without me reading them out now. I hope you will find that a short description of the process. One other thing to note about 117 sub 5 is that there is no reference here to section 94 duty, the general duty. There's no cross-reference, there's no explanation which might suggest that in some way section 117 ought to be subordinated to section 94. Not a bit of it. It's an independent part of the regime. The other point which we should note is that Ofwat or the agency, or there's no involvement of other institutions in the process of deciding whether or not the foul water is foul enough to affect prejudicially, etc., etc., etc. So again, there are no signs that anybody else is involved in that process. It's just a question of fact, and fact for a court, not fact for Ofwat. Mercifully, I'll leave section 117 alone and go to the other proviso, which is 1863, for which you need to go to page 274 in that file. And as I've said, we are concerned with sub 3. We note the heading protective provisions in respect of flood defence works and watercourses, etc. And then sub 3, nothing in the relevant sewerage provisions shall authorise a sewerage undertaker injuriously to affect any reservoir, canal, watercourse, river or stream or any feeder thereof, or the supply, quality or fall of water contained in or in any feeder of any reservoir, canal, watercourse, river or stream, without the consent of any person who would, apart from this Act, be entitled by law to prevent or be relieved against the injurious affection of, or of the supply, quality or fall of water contained in that reservoir, canal, etc. So, a proviso which affects, obviously, discharges affecting water quality, and wording very much suggestive of the fact that this is for the benefit of those who would have who have water rights, if I can put it in that simple term, whether it's riparians or whoever. Wording suggesting that this is protective, this is a provision protective of those persons, and wording suggesting that if there is a discharge which injuriously affects a canal or whatever, those riparians and others would have a common law claim.
Is there a definition of relevant sewerage provisions?
There is indeed. There is a whole, in fact, one of the documents which we handed up, and I think is just on the desk. I don't know whether it made its way to the bench. There's a
Yes.
There's a goodly list. But certainly for my purposes, they really cover all sorts of things, but they include the ones to which I've attached importance. One can see the primary definition as a 1A at the top of the sheet, which includes section 116. One looks at the second sheet, 10, deals with the stopping up of sewers, and you will recall I took you to that section because therein lies the implied right of discharge found by Lord Sumption in the Manchester Ship Canal case. So that's the most important one. It also contains the other one which I attached some importance to, namely section 106, dealing with communications by members of the public into the sewers. So we have a different list as between the provisions listed in 1175 and the relevant sewerage provisions referred to in 186. But certainly for my purposes, the key ones are included in both. And it's the most important one is obviously the 116, the implied right to discharge. One other provision which I should take you to in the Water Industry Act is section 180, which is at page 249. Sorry, forgive me. .269. Which refers off questions of compensation to Schedule 12. And one finds Schedule 12, the relevant part of Schedule 12, at page 290. paragraph 4, subject to the following provisions of this paragraph, a sewerage undertaker shall make full compensation to any person who has sustained damage by reason of the exercise by the undertaker in relation to a matter as to which that person has not been at fault of any of its powers under the relevant sewerage undertaker provisions. So, if compensation therefore goes to those who have been affected by the exercise of powers, compensation does not extend where the works are not exercised, do not have statutory authority. In those circumstances, they're not exercising powers. So we say that's a pointer, another pointer to the 1991 Act when read as a whole, retaining common law liabilities. So if there'd been a discharge of non-foul water which had caused damage, whether by flooding or scour or whatever, compensation goes. Sorry, compensation could be payable. But if it's a result of foul discharge, no compensation under the Act, which we say is a pointer to there being damages claim common law. Now that's those are, I hope, the salient parts of the 1991 Act. And what I should now do, I think we can do this relatively swiftly now that now you've seen all the key sections, is flick through the 1875 Act and the 1936 Act, and quite a lot of these sections will look familiar. The 1875 Act, you will find tab 3, page 25. At and go please within it to page 30 of our bundle, where we see over the course of the next in the course of sections from section 15 onwards, or prototypes of what we now have in the 1991 Act. So section 15 is a sort of early version of section 94. Every local authority shall keep in repair all sewers belonging to them and shall cause to be made such sewers as may be necessary for effectually draining the district of their purposes. Section 16 is powers for making sewers, and that is akin to a pipe laying power, which is found at, I haven't taken you to, but is found at section 159 of the Water Industry Act. Section 17 is important. Sewage to be purified before being discharged into streams. Nothing in this Act shall authorise any local authority to make or use any sewer drain or outfall for the purpose of conveying sewage or filthy water into any natural stream or watercourse, or into any canal, pond or lake, until such sewage or filthy water is freed from all excretious or other foul or noxious matter as would affect or deteriorate the purity and quality of the water in such stream or watercourse or in such canal, pond or lake. So here we have the 1175 proviso in early form, and we have a direct, and it forms the same, but forms the same shape. Nothing shall authorise that. Over the page, section 18. This is the equivalent to section 116, from the implied right to discharge, because someone was entitled to have a sewer, whether the current one or a replacement. And section 19, cleansing sewers. Every local authority should cause the sewers belonging to them to be constructed, covered, ventilated or kept so as not to be a nuisance or injurious to health, to be properly cleansed and emptied, and that in effect has gone into section 94. In page 34 of our bundle, section 299, we have a procedure for complaint to be made to the local government board that a local authority has made default in providing their district with sufficient sewers or in the maintenance of existing sewers, etc., etc. And so you can take proceedings off to the local government board and ultimately seek mandamus. And then at page 35, section 308, where any person sustains any damage by reason of the exercise of any of the powers of this Act. So again, we have similar format, except more generally phrased here to the compensation provisions, which I took you to in Schedule 12 of the 1991 Act. You may have already got from your reading how, until Lord Sumption's judgment in the Manchester Ship Canal case, that the implied right to discharge was not taken from what is now section 116, but is taken from section 17 of the Public Health Act 1875, and that was as a result of a case called Durrant and Branksome, which you may have picked up in your reading. So from the 1875 Act to the 1936 Act, page 40. Here, we're getting a more complex system, but again based around the same structure. So if one starts, please, at page 41, section 14, the effectually draining provision, I think section 94, references to section 22 of page 46. Power of local authority to alter or close public sewers. So we have our, this is the equivalent to section 116, which we saw, which we'd seen the predecessor in the 1875 Act. General duty to maintain at para 23. And then next, please, to page 48, section 30. Again, familiar wording, changed a little bit. Nothing in this part of this Act will authorise the local authority to construct or use any public or other sewer or any drain or outfall for the purpose of conveying foul water into any natural or artificial stream, watercourse, lake, canal, pond or lake, until the water has been so treated as not to affect prejudicially the purity, quality of the water in the stream, watercourse, canal, pond or lake. And then the section 31, thou shalt not commit a nuisance provision, which we'd seen turning up in 117 sub 6 in the 1991 Act. And then the right to connect at section 34 of that page, the predecessor of section 106 in the 1991 Act. Just completing the story, first of all, page 52, section 278, the compensation section. Again, damage by reason of the exercise by the authority of any of their powers. Page 54, section 322, power of minister to enforce exercise of powers by local authority. Similar, different person, but similar exercise, enforcement that we'd seen in the 1875 Act. And then page 56, we have the section 331, we have the predecessor to section 1863. I'll take you in due course to some of the cases which help on some of these earlier provisions, which we say point towards the provisos having similar content. But just before I do that, I should just complete the exercise of sort of bringing things up to date. In privatisation was kicked off by the Water Act 1989, under which transfers of all the assets were made from local authorities to the sewerage water undertakers. But the Water Act 1989 didn't purport to be a Consolidation Act. What it did do was insert an enforcement procedure. We can just pick this up very quickly, please, at page 90 of our bundle. not identical, but a similar structure for enforcement of by what was to be called become Ofwat, then the director, and in section 20 sets out the basic structure, but it's in similar form to the one we looked at in the 1991 Act. Not giving a right under the Act to people directly to seek enforcement or to sue for breach of Statute, section 94. Going through the procedure. All of the provisions that I have taken you to in the 1936 Act, in effect, stayed in place. So you had the Act creating privatisation. You had the Act creating a new and more sophisticated enforcement system. But all of the proviso sections, etc., remained in place for the 2 years until the Consolidated Act in 1991. And if the court wants chapter and verse on that, I'd simply refer, and I won't take you to it, but simply refer to paragraph 8 of Lord Sumption's judgment in the Manchester Ship Canal case, which is at Authorities Bundle 2.5, tab 63, page 1133. It gives one's chapter and verse on.
Which paragraph was that? Sorry. 8.
Paragraph 8, yes.
Thank you.
So the point we make is that we say that there is no question why the provisos should have been interpreted differently between 1989 and 1991, because they were the same old, effectively the same old provisos, and there was the same structure. So, what is it, we rhetorically asked, about the 1991 Act that made the difference? I hope, from my little historical tour, one can see the very great similarities in the structure of the key sections, including the provisos. Even though the 1991 Act takes longer to say things, but the basic structure about nothing shall authorise, etc., hasn't changed. So we then say, well, what is it? What is it about the 1991 consolidation that makes the difference? And if the provisos had an effect in preserving civil remedies up till 1989, up till 1991, what was the change? What was there about the drafting in the 1991 Consolidation Act which made the difference? We say there is nothing to say justified. just moving on and saying a few things about what is effectively our ground one. Which, you'll need core bundle 1 at page 13. Where we seek to criticise the judge for concluding that there was a coextensive breach of Section 94 was necessarily involved, and his conclusion that despite the fact that the discharges was entirely out with statutory authority, nevertheless that breach of the Section 94 duty meant that Section 18 enforcement machinery operated to the exclusion of private tortious remedies. Judge, we say, should have held that private tortious remedies both arose independently of Section 94 and was not inconsistent with the statutory scheme of Section 18. Just thinking about it slightly differently, that if United Utilities is discharging unauthorised discharges, it can hardly say at the same time that it is performing, albeit imperfectly, its Section 94 duties so as to exclude all consideration of its lack of authority. Point I think I made when I was giving you the whistle stop. We say that those acts or omissions ought to lead to two separate legal consequences. The first may be an off-what matter. The second may give rise to common law liabilities. There's nothing, we say, intrinsically unfair or dissonant with the scheme of the Act. You have committed two separate wrongs, which we say have different consequences. One is the failure to deal with the contents of the sewers. The second is to do so in such a way as to prejudicially affect the purity and quality of water.
So you accept that it would be under Section 94, but that doesn't exclude your common law?
That's right. May well be Section 94.
You don't mind whether it does or it doesn't? Exactly.
What matters is what is the construction of the 1991 Act as a whole. We say that there is no essential clash between the Common Law and the Water Industry Act. We're concerned with the consequences of different parts of the Water Industry Act. In circumstances, this is a point I've already made, where there is no built-in subordination by one bit reference to the other. It would have been easy to do if United Utilities were right to say Section 18 dominates all, but the opposite is apparent. Indeed, we have the preservation of independently arising rights in Section 18.8, the mouthful which I read out to you. Now, I said I'd take you to some old cases which help on, we say, on provisos and their construction. And the first, probably the most important, is the Pride of Derby case, for which you'll need Authorities Bundle 2.2, tab 40, page 329. Well-known case involving an angling club suing an industrial polluter, and also two industrial polluters, and also the local authority for the discharge of sewage. And one can pick that up simply looking at the last 10 or so lines of the head note. One should just pick up after the reference to the British Electricity Authority. The plaintiffs based their action on nuisance. Negligence was not alleged. And that is then repeated in so three judgments, and if I can go please to .340 of the bundle. Would it be more helpful to give you bundle references or internal references?
I'm content.
Sorry?
Bundle references are fine, thank you.
Thank you. So 340, the beginning of Lord Evershed's judgment, and talking about the corporation, third and fourth line, their first and main contention is of this nature. It says there are local authority charged with legislation, in this case special legislation, with the duty of providing a sewage system for the county borough of Derby. And the Act is the 1901 Act. And if we can just pick up just a few passages on the way through. 343 bundle. First main paragraph. Now it is clear that if a public authority exercises function to cause a private nuisance to any person, the local authority is liable and constantly sued in this court as any other court, unless he can rely upon any statute by providing by express language or necessary or proper inference of defence to the action. The corporation set up the 1901 Act. We need to look just at a couple of the sections from that Act. Please, first of all, at 344. About 7 or 8 lines down. Most important section for our purposes, section 109. Parish respondent provides the sewage works constructed under the powers of the Act shall all be conducted so it shan't be a nuisance. In particular, the corporation shall not allow any noxious or offensive effluvia to escape therefrom, or to do or permit or suffer any act which will be a nuisance or injurious to the health, reasonable comfort of the inhabitants of respondent. And this act shall not exempt or be deemed to exempt the corporation from any liability for any nuisance arising under sewage disposal works or any proceedings which might, but for this Act, be taken against them under the provisions of the Public Health Acts or otherwise. The other section we should note is 345 bundle, section 113. Corporation may divert all brook, streams, waters, etc., and corporation may, by means of sewers, discharge or permit to flow into the Derwent water so intercepted together with any effluent or other waters. And then the important words, provided that nothing in the part of this Act contained shall authorise the corporation to construct any works or do anything in contravention of the Rivers Pollution Prevention Act or Section 17 of the Public Health Act 1875, and then provision for compensation arising out of the exercise of powers.
So how does this case really help us? Because it turns on a different act.
Because
I suppose you might say there's some loose analogy, but that's all.
Because there are statements by all three members of the Court of Appeal, which I'll take you to, which refer to the effect of Section 17 of the Public Health Act 1875 as depriving the corporation of any defence in nuisance, the claim in nuisance.
Yeah.
So, let me take you to the three passages. I can't pretend the case is the easiest to digest, but I hope with the three passages you'll then see how I put the case. The first is at page 360. And is at the top of the page. In my judgment, therefore, it's presently advised if the Public Health Act is applied to this case, or if, contrary to the view I've expressed, the Act of 1901 ought to be construed as being equivalent in effect to the Public Health Act, there would be no statutory defence available for the corporation for what they are doing in discharging effluent into the Derwent River. And then Lord Justice Denning, 191, sorry, forgive me, at 371 of the bundle, last paragraph. Have they then any statutory authority to commit this nuisance? None at all. This corporation, like other local authorities, has statutory authority to pour a harmless effluent into the river. Again, like other local authorities, they had no authority to pour into the river an effluent which was noxious or polluting. This is made plain by Section 17 of the Public Health Act 1875. And then other acts, and then the conclusion, the corporation are therefore guilty of a nuisance and are liable in damages to any riparian owner or fishery owner who has suffered damage by it. And then the third passage, judgment of Lord Justice Roma, at page 373, two-thirds of the way down the page. Secondly, on the construction, which the Master of Rolls has placed on Section 1, it's impossible to say corporation to say that Parliament impliedly authorised them to commit a nuisance, because it enacted in unmistakable language by that section that it was not to do so, and that this intention of the legislature is fortified, if it needed fortification, by the reference to the Rivers Protection Act 1876 and Section 17 of the 1875 Act. And then it appears plain to me, therefore, the corporation has no statutory defence to plaintiff's action. So, because Section 17 was being, the Court of Appeal accepted, Section 17 was one of the reasons, I mean, other reasons we've seen set out there, one of the reasons why the defence of statutory authority failed. The next case, please, in the same bundle, please, at tab 43, bundle reference 415, Bradstock. And one glance down the head note at 416 to see what it's about. I suspect it's a familiar case. It's a sewer that was in the river. Because flows changed, it was then became proud, and it, looking at the last two lines of 416, caused eddying and turbulence of water, which in turn damaged the plaintiff's bridge and other property of theirs. Then passages we say are relevant. First of all, yes. Lord Justice Harman's judgment, page 438 of judgment. Middle of the page, paragraph starting lastly. Lastly, the statement of claim seeks to rely upon section 331. Remember, that's a 1863 predecessor. This section, however, merely preserves the common law rights of persons injuriously affected and does not arise in the absence of nuisance. And then Lord Justice Russell, please, at 441. Similar effect, 8 or so lines from the bottom. Equally, these considerations dispose of the suggestion that a claim may be founded on section 331. But that section is a mere saving of common law rights. It's put in. Passages are obviously aimed at the suggestion that you can actually sue on section 1863 or on section 331 of the Public Health Act. But it's perfectly plain that the judges consider that they in fact save common law rights. And then in a dissenting judgment, similar from Lord Justice Sachs at page 450. clearest passage in the middle of the page, starting section 331, Public Health Act 1936, which replaces 332 basis, however, manifestly preserves the relevant rights of riparian owners as regards nuisance. Next, please, to British Waterways Board. So that's in bundle 2.3, tab 50, page 596. Court of Appeal and decided that there was no power to discharge into a canal. Reliance in that case being put upon section 159, the pipe laying power, and the Court of Appeal explaining that it simply could not be implied. But at this was a case which did consider the provisos in the 1991 Act. One can pick up the discussion starting at 614 of the bundle. Paragraph 64 of the judgment, they sets out 117, 5 and 6, and then over the page. It's important to note that section 1175 does not confer a power to construct or use a drain or outfall for purpose of discharging surface or foul water into a stream. Rather, it imposes a restriction on doing that in the case of foul water which is not being treated. But there's nothing in sections 102 or 9 or 1116 which could have the effect of permitting or authorising the discharge of surface water or foul water into the land of another or into the stream, watercourse, canal, pond or lake. If a power to do that is conferred by the 1991 Act, it must be found somewhere else. Further, section 116 gives no encouragement to the view that any power that may be conferred elsewhere is likely to authorise the commission of a nuisance. And then,
just before you leave that, can that passage stand with Lord Sumption's analysis in this case, in the MSC case?
No, it can't stand in terms of because such a discharges have been found impliedly to come from section 116.
That's what I thought. So what assistance do we now get from paragraph 64?
I'll move on.
I don't want to stop you making a point if it's a good point, but I haven't yet understood it. I'm sorry.
No, I don't think it does help.
Thank you.
Could I please then go to judgment of Lord Justice Keane, and 621. And it's paragraph 84. Which we would say does help. The answer in respect to 1175 and 1863 seems to be that these provisions do not imply that the consent of the owner occupier, from which the Watercourse is not required. The purpose of these provisions is much wider. They're designed to ensure that those who might be affected by a discharge, but whose consent to the discharge is not required in terms of property rights, are nonetheless protected against damage. Into such category would come those downstream of the discharge who have a right to abstract water of a certain quality, or as riparian owners may be at risk of flooding or other harm. The provisions in question are there to make it clear that their common law remedies, particularly in nuisance, are not affected by the exercise of the statutory powers referred to. On such construction, there's no necessary implication that the undertaker can discharge without the consent or occupier owner of the watercourse. We say that plainly does have independent effect, despite the changing result between the BWB, ultimate changing result between the BWB case and the Manchester Ship Canal case.
The argument that the Court of Appeal was grappling with in the British Waterways Board was solely put on the basis of Section 159.
That's right.
The pipeline.
That's right.
Nobody ran the Section 116 argument, which subsequently succeeded.
That's it.
And I think Lord Sumption said they were right about Section 159.
Yes, he did.
Yeah.
The provisos come in and get examined in the BWB case because one of the things that was said against an implication from Section 159 was that it wasn't linked in to the provisos.
Yes.
That's why they're being examined with some care here, we are, of course. This is the first case I've taken you to where we are actually looking at the 1991 Act. Can I now take you to the Manchester Ship Canal case itself, which is in volume 2.5, tab 63. And I'll be seeking to draw from this really 2 points. One is that the court had in mind the retention of common law claims, and the second is that the correct tort involved is that of trespass. And we can pick that up very early on in Lord Sumption's judgment, please. 1131. Paragraph 2. Discharge into a private watercourse is an entry on the owner's land and as such is an unlawful trespass unless it is authorised by statute. And then can it be implied, the context here of course being that we were not concerned with a foul water discharge, we were and then please to paragraph 17, 1137. At the end of paragraph 17, he's talking about the consequence of a discharge having to cease forthwith on 1st December 1991. Any continuing discharge thereafter becomes tortious from that date. And then paragraph 22, please.
That is unless the, sorry, after you.
That's not a statement of what the position is. That's a statement of what the position would be if the argument were accepted.
Yes, indeed. Yes, absolutely.
Because you have to read it with the previous sentence, unless the entitlement survives,
Exactly.
it would be tortious.
Yeah.
Yes. But the entitlement does survive.
But he's not, absolutely, but he's not saying,
It's just if you read that sentence on its own, it sounds like a statement of fact, but it's not. It's exactly the opposite is the fact.
I'm taking
Continuing discharges are not tortious after 1st December 1991 because the right does survive.
Yes.
Yes. Right. I think I understand. It's a bit misleading just to take that one sentence.
I'm taking it too fast, I'm afraid. But the point being that a recognition that if there is a discharge without statutory authority, it's tortious.
And you say, reading with paragraph 2, what he means is it would be a trespass.
Yes.
Yes.
And then please to paragraph 22 at 1138. I should finally deal with the suggestion that this conclusion, that there is an implication, leaves that the owners of private watercourses in a worse position than they were under the Water Act because of more limited provisions for compensation for damage and the more limited protections available against abuse. This is a serious objection to the attempt to apply a general right to discharge into private watercourse from section 159, as the Court of Appeal pointed out in the British Watercourse. It does not give rise to difficulty if, as I consider, a more limited right to continue discharging from existing outfalls into private watercourses to be applied from the restrictions in section 116 on discontinuing the use of existing sewers. As far as compensation is concerned, Schedule 12, paragraph 4 of the Water Industry confers a right of full compensation for any exercise of the undertaker's powers under the relevant sewage provisions. Unlike section 159, section 116 is one of the relevant sewage provisions. Turning to the question of statutory protection, the 1991 Act contains a large number of protections against the abusive or harmful use of undertakers of their statutory powers. This is not the point to examine them all. Many are of no relevance. The most important are to be found in 1175 and 186. 1175B protects against the discharge of foul water into watercourses. It's the successor of 17 section 30. Section 186(3) protects against injurious affection without consent of any canal, watercourse, or the supply, quality, or fall of water from any canal or watercourses. Both provisions expressly qualify powers derived from specified provisions of the Act, which does not include section 159, but do include section 116. So I'm there referring to Lord Sumption's approach to these sections as giving significant protections, and in my respectful submission, the arguments of UU, where they say what the provisos do doesn't accord, but does not give them does not give third parties such as the canal any powerful protection against abusive or harmful use by undertakers of their statutory powers. Lords Clark and Hughes agreed with Lord Sumption. Then at take please to Lord Toulson's judgment 1141. Paragraph 36 concerning trespass, and I think probably the point made there is the same point which you pulled me up on earlier in respect of there is no claim for trespass, etc., etc. But it still makes the same point that the court is regarding trespass as a possibility, were it for the fact that there was statutory authority given that period.
Basically, your point is in relation to the bottom of paragraph 36, Lord Toulson wouldn't be saying, the conclusion is clear in my view, that sewerage undertakers did not commit the tort of trespass by continuing use of the public sewers which they inherited, if in fact he didn't think that there was a possibility that there would be a tortious claim.
Exactly. Nothing said by the Supreme Court in this case is suggestive of them thinking that there wasn't a tortious claim out there. Archich was mentioned in argument in Manchester Ship Canal, but no observations by the court on that. But it's quite, we say it's quite telling that in the context where, again, like the BWB case, the provisos are in play, that the court is considering that there's no reason why there should not be a common law claim.
It slightly depends on the way in which the arguments were framed. I mean, the ratio of this case is that there's an implied right under Section 116 to continue using pre-1991 sewers.
Yes.
And no implied right to continue using future sewers. That's the ratio. Now, it may or may not, in those circumstances, have been argued that even if there were a breach of the provisos which would otherwise be a trespass, you couldn't sue for trespass or nuisance because of the Marchurch principle? Unless we examine what was argued, which I don't suggest we do, it's not clear that we get that from the case. It's a purely negative point. They didn't say, but of course you couldn't sue for trespass anyway.
Just one reflection on the effects of the Consolidation Act if UU arrives. We know that one outcome of the litigation was that undertakers were deprived of their long-standing right to discharge non-fouled into private water bodies without consent. If they knew sewers. If they were new sewers and they discharged, then it would be trespass. There is a little bit of an irony in this that so for clean water you have a claim in trespass, whereas what UU is saying is that an effect of the Water Industry Act 1991 is to deprive property owners of their long-established right to bring common law claims in respect of non-negligent discharge of foul water. So there's a sort of mismatch, one might think, if UU were right on that. And it does rather cast doubt upon whether that, as a whole, can be derived from the Act. I'll move now to statutory ouster. Just to remind ourselves of the general contours of it, by looking at the Town Property Action Group case, for which you will need bundle 2.4. Tab 58. Head note at 945 reminds us as to what it was about. The Secretary of State trying to recover overpayments via a restitutionary claim rather than via a statutory route. And the section which helps on the general principles we can find the trees at 961, judgment of Dyson. Your Lordships will have the sidelined passages from 32 to 34. Last couple of lines on the page, nothing in the reasoning of the tax case to indicate the courts were applying a rule peculiar to tax cases equal amounts in total to non-tax cases such as Marchurch and paragraphs on the principles. Two remedies cover precisely the same ground and inconsistent with each other, then the common law remedy will almost certainly have been excluded by necessary implication. To do otherwise would circumvent the intention of Parliament. A good example of this is Marchage, where a sewage undertaker was subject to an elaborate scheme of statutory regulation which included an independent regulator with powers of enforcement, whose decisions were subject to judicial review. The statutory scheme provided a procedure making complaints to the regulator. The House of Lords held that the cause of action in nuisance would be inconsistent with the statutory scheme if it would run counter to the intent of Parliament. The question is not whether there are any differences between the common law remedy and the statutory scheme. There may well be difference. The question is whether the differences are so substantial that they demonstrate that Parliament could not have intended the common law remedy to survive the introduction of the statutory scheme. The court should not be too ready to find that a common law remedy has been displaced by a statutory one, not least because it's always open to Parliament to make the position clear by stating explicitly whether the statute is intended to be exhaustive. The mere fact that there are some differences between the common law and the statutory positions is unlikely to be sufficient if they are substantial. The fact that the House of Lords was divided in total shows how difficult it may be sometimes to decide on which side the case falls. The question is, when looked as a whole, would a common law remedy be incompatible with the statutory scheme and therefore could not have had it intended to coexist with it?
Could I just ask a quick question about that passage? Because I find the reasoning a little puzzling. On the one hand, Lord Dyson says that the question is whether the common law remedy is excluded by necessary implication, and he says that the question is whether it's incompatible with the statutory scheme. That reasoning I understand. But then there's a second strand in the reasoning, which is about whether the differences are big or small. And I don't see what that's got to do with it. Can you elucidate?
Well, if the differences are, perhaps the key to that is in the second sentence of 34. The question is whether the differences are so substantial that they demonstrate that Parliament could not have intended the common law remedy to survive the introduction of the statutory scheme.
But nevertheless, that seems still to be different from incompatibility, which is at the end of paragraph 34.
Yeah.
Does he mean that if the differences are small, they're less likely to be incompatible?
Yes.
Suppose you can get damages of £10,000 under statute and damages of £100,000 under common law. That might be thought to be a large difference in terms of the quantum of the damages, but in terms of the principle, why does it matter?
Well, it really comes down to why is it inimical to the statutory scheme for greater damages to be awarded under the common law? They may be perfectly consistent.
Or it may be an indicator that, in fact, they are incompatible because the statute provides for a fixed penalty of some kind, which would be incompatible with damages at large.
Yes, if there were good reason for the fixed system ousting the larger entitlement to damages.
Well, I can quite see that if there is a statutory cap on damages recoverable, then of course it's inconsistent with that to have damages exceeding the statutory cap. But that would be true in my example if at common law you got £10,000 and a single additional pound, or it was £11,000. So you could have a small difference in quantum terms, but the effect would be the same. And that's because if you've got a cap, it's plainly inconsistent. It's got nothing to do with the size of the difference.
Yes. An example which comes to mind is that under the Criminal Injuries Compensation Scheme, damages are often in a capped sum. That does not stop an injured claimant taking his recourse at common law if he happens to have a criminal defendant who's up for the money. They're different systems. One is convenient, low cost. The other one is you have to run all the gamut of ordinary civil litigation.
Thank you.
So just to distill the point for us, what do you say we take, therefore, from this passage from Lord Dyson's judgment? What do you want from it?
I want the court to be guided by what is perhaps the most recent statement of high authority.
And how do you interpret it?
Well, I interpret it as it's still a matter of construction, and you have to construe the whole the two different, potentially similar or different schemes and common law remedy. I take from it also the fact that it would have been the middle of 34. It would have been perfectly easy for the legislature in 1991 to make section 94 dominant, section 18 dominant, and specifically caveat the provisos accordingly, which didn't happen. The provisos pretty much sailed on as before.
Thank you.
And just give me a moment. Before we go to much, can I invite the court to have a look at our submissions on it, which are to be found in 4 bundle 1, page 31. and the judge's conclusion at 83, which I set out at 44, stands for a broad principle derived from the structure of the 1991, not a narrow principle. There's no claim of nuisance for failure to build more sewers. And our submission is that that is an overbroad reading of Marchich, which was the central judgment, the central area showing the principle is to be found at Lord Hoffman when considering whether or not that it was a case about the lack of a common law claim for not building sewers. As I said at the beginning of my submissions, this point in a sense is not actually critical to the way I put the case, for the simple reason that we are here considered with, we are dealing with a set of statutory provisions which were not the same as in Marchich. Here considering the provisos, which were not obviously at play in Marchich, because in Marchich it was sewage affecting Mr. Marchich's garden. So there was no discharge into a stream or anything, and therefore Marchich gave inevitably no consideration to what the provisos meant.
But I'm not sure I've quite understood this. In Marchich's case, the discharge was into his garden and his house, but it was accepted that it would have been a nuisance if it had been done by someone who wasn't a statutory undertaker with the benefit of the 1991 Act. And the decision was, even though it would otherwise have been a nuisance, the structure of the Act precluded Mr. Marchich from bringing a private law claim. His only remedy was to ask the Director General or Ofwat to make an order requiring Thames Water to build more sewers. Now, in your case, the thrust of your case is that because the provisos have not been complied with, what is being done is a trespass or a nuisance. I think you say trespass. But the argument you're facing is exactly the same, which is it would otherwise have been a nuisance, but because it's a water undertaker who's doing, sewage undertaker who's doing it under the 1991 Act, the only remedy is by complaining to Ofwat and getting an order under Section 18. So what is the relevant difference? Of course, in your case, you rely on the proviso to show that it wasn't authorised, but I don't understand, Mr. Karras, to dispute that if it wasn't for the Act, you wouldn't be entitled to do it.
Well, we say that makes the difference, because
What's the difference?
well, the difference is that because United Utilities are not acting within the scope of the Act, because they're not entitled to do it, the scheme which is conferred by the Act should not disable us from claiming.
But in effect, your complaint is that they should build more sewers, is it not? I mean, that's what the judge said. Is that wrong?
No, that's right.
So if Mr. Marchich says you should build more sewers because I don't want you flooding my garden and house, and you say you should build more sewers because I don't want you polluting my canal, what is the relevant difference?
It's a different legal analysis as between something which falls outside the powers of the undertaker, i.e. foul water proviso, and some.
But Thames Water had no statutory authority to flood Mr. March's house with sewage. Did it? It was a breach of Section 94 in March's. Yes, so they don't have statutory power to do it. They're in breach of the Act. So, in both cases, the sewerage undertaker is failing to comply with the statutory duties in the Act. In your case, because it's in breach of the proviso. In Mr. March's case, simply because it's in breach of Section 94. You'll have to show it. I don't want to take you out of your course. You'll have to show us. But I've not understood why there's a fundamental difference between the two cases.
Because it's a, I think I'm repeating myself, but because it's an entirely different legal situation. One where the undertaker is acting specifically outside powers which are set out in the statute, and two, where the undertaker is in breach of Section 94. We have the benefit of the provisos, which govern discharges, and so the whole question before this court simply did not arise in the March's case. So, in circumstances where I hope to have demonstrated the continuity of the of the fact that there was common law rights in proviso cases or proviso type cases in the case law, where the Act, when the legislation was consolidated in 1991, we don't see anything suggesting that there was intended to be a change of the system. So it would be perfectly consistent, we say, for a claim to be common law claim to survive in a case of lack of authority, but on the other hand, in a more straightforwardly Section 94 case, if I can use that phrase, it's caught by the decision in the principle in March's.
Thank you.
So the point really comes down to a construction of these particular parts of the Act, obviously seen in the context of the rest, which simply wasn't there in March's. Didn't need to be. One has to come, all cases of statutory ouster, one has to come back and construe the Act and construe the relevant bits of the Act that are an issue, rather than, so to speak, assuming that Section 18, Section 94 dominate everything. You just have to ask yourself, given the particular provisions at issue, whether that in fact is the correct interpretation of the Act as a whole.
And just so that I'm clear, do you challenge the analysis which puts the conduct back under Section 94 and therefore Section 18 in the first place? In the sense that you say this is different from March's in that respect too. that it's artificial, is it, that one then sees the conduct and puts it back under Section 94 as a breach of those express duties? Or do you not take that one?
Yes, I take the point that you have to look at the particular provisions, the provisos, and then say, just because they could be couched as Section 94 breaches, often are, not necessarily, but often are, any consideration of the remedies in respect of the provisos are subordinated to.
Thank you. I'm sorry, I think we've taken you out of your stride a little bit.
Not at all. I think
You're going to take this to Marchich, I think.
yes. So, bundle 2.3. Tab 51. I appreciate the court will have read the case, and so I'm anxious not to take up unnecessary time. The court will be aware of Lord Nichols's speech, and in particular his sort of, in effect, his conclusions, which page 638, paragraphs 34 to 35, and the conclusion, really at lesser f, the existence of parallel common law right whereby individual households who suffered surfeit may bring court proceedings when no enforcement orders be made would set at naught the statutory scheme. The question is how one accords that with the precise way in which Lord Hoffman expressed himself, and this is, please, that paragraph 52. Section 18A follows that if the failure to improve the so as to meet the increased demand gives rise to a cause of action at common law, it's not excluded by the statute. The question is whether there is such a cause of action. Flooding's not been due to any failure by Thames. They have a statutory duty to accept. The omission relied on by Mr. March is given to an actionable nuisance is their failure to construct new sewers with a greater capacity. And then paragraph 54. In the particular case of referring to the old cases and I simply draw the last sentence that the courts consistently held that failure to construct new sewers was not such a nuisance. Well, the polluting of the canal on ordinary principles would be a nuisance. So that's why I asked the court to reflect on whether a very significant part of the reasoning, certainly of Lord Hoffman's, is the fact that there never was a case involving failure to construct new sewers. That was simply not a tort. As distinct, what I've just said, as distinct from the fact that a pollution of water without statutory authority is a tort. I don't seek to take the court to any further parts of March's, simply because your lordships will know it well already, and I've made my point on that. Can I?
I was just going to say, is that a convenient moment, Mr. Hart?
Yes, it would be. Yes, thank you.
And how are you doing?
I think I'm doing pretty well. I think I might conceivably be coming under budget, but we'll see.
Okay, on that basis, unless anyone wants to add anything, thank you. 2 o'clock.